Welcome to this presentation in which we're going to talk about case briefs. This is an important topic for paralegals and attorneys to be familiar with, and we'll actually be spending a significant amount of the time in this course working on case briefs. The case brief that you are working on this class, you will actually write multiple times, and you will assist other students in their case brief work. We use the case brief in this class for a couple of different purposes. For one, the purpose that I guess it's ordinarily intended, which is to communicate the meaning of a particular judicial opinion. And then probably the second purpose that we're going to be using, which is a little bit, I'm not going to say unusual, but it's a little bit different than maybe the traditional, is that I'm using the case brief as a stepping stone to prepare you to write legal memoranda. So we'll see sometimes where I tweak a little bit of the direction that maybe you would ordinarily go with a case brief in order to help bridge that gap to the legal memorandum that we'll be working on this semester. Okay, so what is a case brief? Here's a definition. A case brief is a summary. Let me just highlight that word here. Is a summary, and it's an analysis. These are two important ideas that we want to communicate when we're doing our case brief. Of a judicial opinion prepared for the benefit of the writer. So it's for you. It's not for anyone else. Obviously, in this class, you're in some sense preparing it for me because I'm the one grading it, but that's a bit of an artificial constraint. Most of the time when people write a case brief, they don't intend for anybody else to see it other than possibly the people with whom they are studying with. It is a set of notes organized in a systematic way designed to sort out the parties, identify the issues, ascertain what is decided, and analyze the reasoning behind the decision. The most common time in a legal professional's life where he or she case briefs, and this is commonly used as a verb, even though in this form it's a noun, a case brief, case briefing, is when somebody is in law school. Let me explain a little bit of how law school classes typically work. While a law school class covers the same type of material that we cover in a paralegal course, the format is usually very different. What will happen in a law school class, especially a first-year law school class, is typically that you will be in a large classroom. There were about 140 in each one of my classes that I had in law school. And you will have an assigned seat, and the instructor will have a seating chart. The instructor will have assigned probably about 4 or 5 judicial opinions for the class to read for the next day. These are typically in a textbook, but the textbook is really primarily just a collection of judicial opinions. There's a little bit of discussion from one judicial opinion to the next, but probably 80 to 90% of the contents of the textbook are those judicial opinions. And in fact, it's rather intentional. Law school textbooks are designed not to give away a lot of answers. The goal is for the student to make the connections and not to be told what those connections are. So as a result, a law school class is very different from a paralegal class in that the students are talking most of the time. So the beginning class comes, the instructor calls on a student in class, the student stands up, and usually the class is rather formal. The students are called Mr. or Ms., and the instructor will start asking questions. Miss Green, what are the facts of the James versus Harris case? And then Miss Smith will stand up and she will recite the facts of the case. And then very likely the instructor will ask, well, what was the holding? How did the court reach that holding? All of the same all the same questions that a case brief should answer. Once the facts and the background of the case are explained to the class, then the instructor will start kind of deconstructing the case and offering lots of hypotheticals. Well, let's imagine the facts were a little different. How would the judge have decided the case then? What's your support for that? How would this judge decide this other case? Or maybe the case that we learned about last week, is the reasoning consistent between the two cases? and the student again would be answering all of these questions. As you can imagine, that's a pretty stressful situation to be in if you're the student. You're in front of 139 of your peers, and the questions are tough, and it never seems like you're answering them the way the instructor would like for you to answer them. The instructor almost never says anything. It's almost always just asking questions. That's called the Socratic method. So you can see under those circumstances, it's really important for your self-esteem to have these case briefs so that you can look down and look at your notes, because of course you're quite nervous when you get called on. In some classes, it's pretty obvious, maybe the instructor calls on people alphabetically or by the seating charts, and some instructors do it randomly. So that's what the case brief is for, and in law school people typically prepare these, and they bring them to class along with their textbook. It's not uncommon for law students to be in what's called a study group. I guess that's not a particularly unique name to law school, is it? You might have anywhere from 2 to maybe 4 or 5 students in your group, and maybe each one of you briefs one of the cases that we're going to cover during the next class, and then distributes those case briefs, and then everybody has some document to use. And of course that means if you have 5 people in your group, you only have to brief 20% as many cases as somebody who's briefing cases all on his own or her own. So that's kind of the origin of a case brief. Obviously that's not how our classes run. We don't read a ton of classes outside of probably this class and legal research. Typically what happens is the textbook will summarize what a particular case or a category of cases say, or perhaps the instructor will summarize it. That makes a lot of sense in paralegal courses, because the amount of time and effort that it takes to read and process all those cases would turn our courses into much more of a time suck. You'd be spending a ton of time in these classes, way more than you already do. So what we do is it's kind of like a murder mystery. We give away who done it. We tell you what the answer is, as opposed to you arriving at the answer, because it's easier. It's easier for everybody. So we don't have as much of a reason in our courses to actually prepare case briefs, but they still can be useful in the practice of law, because many times you will be preparing a legal memoranda and you will have looked at lots of different cases, and you may want to actually deconstruct the most important case or the couple most important cases and really kind of get inside the mind of that judge so that you can make sense of it. And that would be how a case brief might be approached. So that gives you an overview of how a case brief works. So how is a case brief different than a memorandum? Well, a memorandum is focused on a particular issue. Sometimes more than one issue, but generally a collection or a few legal issues. A case brief is focused on one case. So a memorandum is going to cite many different cases, many different statutes. A case brief is just going to focus on that one case. Now, it is possible that the case that you're focusing on cites other cases or cites statutes, and then, of course, you're going to be talking about those cases and those statutes. But you're looking at those cases and those statutes through the lens of the judge who wrote the opinion. And so you're focusing like a laser beam on the case, unlike the memorandum where you're focusing like a laser beam on that particular issue. That's the big difference. Typically, a case brief is going to be a lot shorter than a legal memorandum. So, why prepare a case brief? Again, we talked about it from the perspective of the law student. It's designed as a self-help measure. It is a study aid, a preparation aid. And of course, when I say himself, it could be or herself. And the members of the study group to understand these things about the case. Who are the parties in the case? Not the names, although obviously you need to know the names, but how do they relate to each other? Mrs. Smith, well, who is she? What's her story? How does she relate to Mr. Brown under the circumstances? And then the facts of the case. This may seem pretty straightforward, and it is in many cases. It's probably the easiest part of the case brief to write. But you have to be able to sort through what are the important facts and what are the unimportant facts. For example, let's imagine in the story, Mrs. James was wearing a blue blouse. Well, probably the color of her blouse is not important to the case. It's just an extra fact that the judge added to the case. So that would be an example of a fact that you'd probably leave out of your case brief. On the other hand, let's say Mrs. James is suing Mr. Brown because Mr. Brown had made a shirt that Mrs. James was going to buy, and Mr. Brown had told her it was going to be blue, and in fact it was green. Well, now the color of the case is important, and so obviously you're going to be talking about the color. So sorting out the relevant from the irrelevant facts is an important part of this particular section. Then you're going to identify the issues. Many times the best written legal opinions will actually tell you what the issues are. They'll be very clear. These are the issues, and they'll even write them out in a way that you can kind of cut and paste them. That is commonly done. It is not always done by the judges. And so we'll talk about how to find issues, what are the words that we're looking for, and how to translate the text in the judicial opinion into the wording that you'd want to use in your case brief. Then we're going to talk about the holding of the case. What is the holding? In legal circles, the term holding has a special meaning. It means what is the rationale of the case? What is the logic of the case? What is the timeless legal concept that the judge is elucidating for us? It is something that is going to apply to many other fact patterns in many other cases. It's not tied exclusively to the plight of the parties in this case. The disposition is related to the holding. If you know the holding, you can probably figure out the disposition, but the disposition is a little bit different. It's about these particular litigants. It is really exclusively about who gets what and what's the next step in their lawsuit. As a result, the disposition isn't nearly as important to you as a case reader as it is to the parties, because after all, you're not representing those parties in a way you don't really care what happened to them one way or the other. So the holding is the more important thing, but the disposition helps you understand the holding and exactly see what the repercussions of this holding might be, perhaps for your client. The analysis is how the court got to the holding that it reached. The holding, again, is maybe the topic sentence in some way of looking at it, and the analysis is why that topic sentence is the topic sentence. This is what you're doing the case brief about. The rest of this stuff is lovely and you need it and it's great, and I guess a holding you might also put into bold too. But honestly, all of these other tools are there simply so that the reader can understand this part. We don't care about the facts because we care about the facts. We care about the facts because the facts are part of the analysis that's going to help us understand the holding. If there's a fact in the opinion that you aren't ever going to mention in your analysis, why would you add it to your facts section? No reason to. It's not helping you analyze the case. This isn't a book report. You're not reading this case because you happen to enjoy that type of case. No, you're reading it for a very practical purpose. You want to understand how the court got to where it got to. And if the fact that Mrs. James was wearing a blue blouse doesn't help you get there, then you wouldn't include it. So look for this. If you tell your factual background, but there are facts in there that you never use in your analysis, those facts probably need to go away. Because again, one of your goals is summary. You want to be relatively brief. So anything that you can cut out that doesn't help you get to this, you want to cut out. Who uses case brief? We said before it's mainly law students. That's certainly the most common. But they can also be used by anyone who wants to really dive down deep, kind of almost psychoanalyze the judge in the case. And so in an important case, when you're researching an issue, it can be a very helpful tool. And even when you aren't using it directly, even if you don't sit down and formally write out a case brief, using the skills that we cover in this section may help you informally to apply those skills when you're writing your legal memoranda, when you're analyzing cases. So you might not go through these exact steps in your real practice, but hopefully you'll take the concepts and the parts that seem of value to you as you analyze cases in the future. Let's talk about a paradigm. This is a common one. It's not the only way to organize a case brief, but it is the classic way. It's the one you'll hear most often. You use the acronym IRAC, and you can see it's kind of like the country of Iraq, but it's pronounced differently and it's spelled differently. But that can be the way that you think about it, so that you can kind of have the mnemonic in your mind. Is this the only way to organize a case brief? Absolutely not. In fact, we'll be seeing some other ways before this lecture is over. But this is the mechanism that we're going to use. So please, even if you love another mechanism, you're welcome to use that once you're out practicing. But for the purpose of this class, this is the organizing principle that we're going to use. Okay, so let's talk. We first of all have the issue. That is what the question that the court is trying to resolve. You know, obviously, if someone doesn't file a lawsuit, doesn't appeal whatever happened to the trial court level, unless he or she thinks that he or she has a legal basis. And typically, when one person thinks that there's a basis for appeal, the other person disagrees. And so there's an issue there. And one side is saying yes, the other side is saying no. And so now the judge has to decide, well, which is right? Is the side that says yes right? Is the side that says no right? That's the issue. Many times judicial opinions will have more than one issue. In fact, I would say more often than not, they do have more than one issue. Many times they're closely connected. Sometimes they're completely different. They may have the person who appealed may have a procedural issue as well as a substantive issue. I once worked on appeal where one of the parties had 37, I believe it's 37 issues on appeal. That is an outrageous number of points of error. But having 2, 3, 4, even 5 would not be unusual. So you can have lots of issues. Typically, a point of error, a point which is the basis of the appeal, is going to generate an issue. So we have our issue, and again, we might have many issues, but we've identified at least one issue. Now we're going to look for the rule of law. There can actually be, for each issue, more than one rule of law. I would say commonly there is. There may be a statute that controls. Well, that would be the rule of law. There may be one or more cases that are important in this area. Again, those would be rules of law. There may be a regulation or an executive order. All of those could be rules of law. There will be times where there's just one case, that's all you have to think about. But probably more often than not, you're going to have multiple judicial opinions cited or multiple statutes. This is usually pretty easy to find because you just look for what are the decisions that are cited in the opinion? What are the statutes that are cited in the opinion? Of course, you'll have to sort it because if there's multiple issues, you'll have to make sure you get the rules of law for each issue separate. So issue 1, you might have 2 rules of law. Issue 2, you might have 3 rules of law. Issue 3, you might only have 1 rule of law. So once you've identified the rules of law, the statutes are the cases that help you come up with the answer to the issue. Then you're going to apply that law, these same rules, you apply these rules of law, which is the law, to the facts. Now we haven't talked about where facts go in this analysis. And let me just show you how I approach it. I don't know if I'm the only person who does this, but I actually call this FIRAC. It's my own little thing. So I actually put an F in front of here, FIRAC. That's not quite as catchy as IRAC, but I start with my facts. And so obviously you have to list the facts, and so you list your facts and your issue and your rule of law, and now you take this rule of law and apply it to the facts. And again, that's why you don't need extra facts. If you're not using the facts in your application, then you don't need that fact up here. A good rule of thumb is actually to save writing your facts until the very end. And then you go back to your application and see which facts you used. And then you might look at all of the facts that you know about, and you won't know a ton of facts, to be honest with you, in most printed opinions, and look through and see, well, I never used this fact, I never used this fact. Occasionally, though, you'll come across the fact and you go, you know what, I never used this fact, but that really would help my application of law to facts. So then you go and add that fact to your application of law to facts. And then, of course, you would find all the facts that you used and go back and put it into your facts section. Now, I will tell you, many students write the facts section first. That's not wrong. That's not bad. I mean, obviously, I won't know which order you do things, but it's probably not a best practice because You don't know yet, because you haven't done your analysis, which facts are actually going to help you with your application. So if you write this first, then you write your application, you may discover that you end up cutting half or 70% of your facts, and you will have wasted that effort. So in terms of efficiency, spending the least amount of time to get the most bang from your minute, start with the issue, the rule of law, the application of law to facts. Then here, if you want to, go back, pull out all the facts that you use, and write your fact section. Another term for this A section, instead of application of law to facts, is analysis. I actually prefer application of law to facts because it reminds the person preparing the brief that, okay, I'm going to be talking about this, and I'm going to be talking about this. I'm going to be putting the two together. If you have this section and you're not citing the rules, the statutes, or the cases, or you're not citing the facts, then you're not doing what this is all about. If you have a rule of law but you never mention it here, you've got the same problem. Why list a rule of law if it's not applicable to that particular case? So be sure that you are using your rules of law in your application of law to facts, and you're using all of the facts that you've included up here, down here. You can call this section analysis if you want to, but also keep this in mind, application of law to facts. And then you're going to have a brief conclusion. Okay? That's an overview of the structure. So let's talk about how to brief a case. Well, the first thing you're going to want to do is you're going to be efficient with your time. You're going to want to look, you're going to go to your reporter and pull up the case. If you have access to Westlaw, then of course you can do it electronically. If you don't, then you can go to the Spring Creek Library and pull the book off the shelf if it's a Southwestern Reporter case. And you're going to look at the beginning of the opinion. You turn the right page, and even before the opinion starts, you'll see that there's what's called a syllabus. Now, when you and I use this term in everyday conversation, we mean that document that you get on the first day of class, right? That word means the same thing as this word, but we use it in a very specialized sense. A syllabus is a summary. And so just like the document that you get on your first day of class is a summary of all the stuff you need to know to be successful in class, a syllabus is a summary of the judicial opinion. But there's an important difference between the syllabus that's published in the reporter series from the actual published opinion. The judge writes the published opinion. The syllabus, the judge does not write. In fact, an editor or group of editors at West writes that. They're just private citizens. They're very knowledgeable, very smart, good writers. They've got a lot of positive things about them, but they are not the judge. And so if one of them, say, had a few too many drinks over lunch and comes back and completely misunderstands the case, writes up the syllabus, somehow or another gets published, and so the syllabus is absolutely wrong, well, guess what? That editor's probably going to get fired. Too bad for him. But more importantly for us, the law wasn't changed. The fact that the syllabus says something that's incorrect has not changed the law one little bit, because the syllabus, as well as the headnotes, which we'll talk about in a second, are all secondary legal sources. They describe the law. They help us understand the law, but they themselves are not the primary source of law. They aren't the actual published opinion. So the syllabus gives us a nice brief summary, and usually it tells you what the holding is in a very clear way. And so that's a very helpful document to look at. Another document that can be really helpful are the headnotes. Again, these are prepared by Westlaw, or West Publisher, and they also appear in Westlaw. And these are they break down the law into kind of bite-sized pieces. And so in an opinion, say that's 4 pages long, you might have 10 headnotes. And so you might end up having about 2 to 3 headnotes per page. And the goal here is it'll find the individual nuggets of law, and it will have a note for each one of those little nuggets of law. And so you can look at that. And that's going to, typically the headnotes are going to be lengthier in total than the syllabus is. So the syllabus is, the one paragraph summary about the case. The headnotes are kind of like the Cliff Notes version. Shorter than the actual opinion, but probably maybe a third or fourth as long as the actual opinion, so they're not a ton shorter. Then, of course, you can Google material. If it's a big case, you might find lots and lots of content. If it's not such a big case, there may not be anything. Obviously, especially with the Google material, you ought to approach the material with a critical eye. Is this really solid legal work? Obviously, if you're going to cite it, you need to agree with it. You need to have looked at it and say, you know what, I agree with that analysis. It's okay if you don't. It's okay if you don't agree with any of these tools, just so long as you have a reason why you don't agree with them. That's the important thing. Okay, here are some strategies about how to brief a case. Again, if you find 100 legal professionals, you will find 101 ways to brief a case. So there's nothing magical about what I'm suggesting. This isn't the only way. The way I'm suggesting is a fairly time-intensive way of doing it, but it's also a pretty rock-solid way. It's almost connect the dots. You can't really mess up too much on this one. So if you decide to veer from this path, not saying you're wrong to, but you're probably opening yourself up to possibly getting lost in the weeds, and we don't want that to happen. So the first thing to do is read the case. Just read it, just like you would a novel or something else. It's going to be hard. Most judicial opinions don't read like mystery novels. No surprise there, right? Most don't read like textbooks. They are hard reading. The case that I have selected for the case brief is, I think, an easy case to read. I chose it so that it wouldn't be overwhelming. But just so you'll know, there can be cases where you read it once and you may be thinking to yourself, if you're like me at least, what just happened there? I have no clue. So reading it once is not going to be enough. In fact, you may even need to read it more than once before you're really even able to start processing it. So what are you doing to this first read? Well, you're getting an overview of the case. You're figuring out the structure of it. How did the judge organize it? In most cases, the judge is going to use some headings, so you have some hints about the organization. And then you're also developing a to-do list. What are the things that you need, the work that you need to do to make sense of this case? What are the sections that you are like, huh? Are there words that you need to look up? Are there concepts that you aren't familiar with because you just haven't been exposed to them? So you're going to have to do some independent research to even make sense about what the judge is talking about. Maybe one of the items on your to-do list is coming to see me. That would be awesome. So put that definitely on your list. There can be other things too that you want to look at. You may want to figure out, stop and think, well, why did the judge put those two items in there? Why did the judge not talk about this item? Why did the judge put this first or that first? The best judges that are the best writing judges are going to have a reason for all of those questions. And so it's sometimes useful to think about them as you struggle to master the content. As you're reading, and I encourage you to print up the case, although you certainly don't have to, but I recommend that you mark things that you're not familiar with or you're not sure about. Even if it's a term you kind of, sort of, almost know what it means, go ahead and actually look it up. And it can be a legal term, or it might just be an everyday term that you aren't quite sure what it means. And if there are sections that just throw you, put a question mark or some other mark by it so that you know you're going to have to spend more time with that. I wouldn't, through this first read through, get bogged down in understanding every word, understanding every concept. Otherwise, it's going to take you hours to read it, and you're going to forget the beginning part by the time you get to the end part. It's going to seem like a really overwhelming task. So I wouldn't call it skimming, but I would call it reading, understanding that you're not going to get it all that first time. Okay, now you're going to read the case again slowly. And my recommendation is when you see a paragraph, think to yourself, okay, you and I are wrestling. You and I are I'm going to win, paragraph, but it's going to take me some time to pin you. And that's your goal. You need to work with the paragraph until you say, you know what, I'm an expert on this paragraph. I can tell you everything that's in it, why it's in it, why this sentence comes before this sentence, how this sentence relates to the paragraph in front of it. The way to do this is to spend the time. I mean, there is no magic pill I can give you. There's no pixie dust you can sprinkle over the chapter. The paragraph. You just have to wrestle with it. Writing it out, taking notes can be a good way to work with it. Obviously, these notes are just for you. They can be as silly and as cantankerous as you want them to be. your notes, especially if it's a tough paragraph, will be longer than the paragraph. That's not at all unusual. That's okay. In fact, that's a good sign. If it's one of those really important paragraphs in the case, fight with it, wrestle with it. Don't concede. Don't walk away from that paragraph until you are the expert in the paragraph. You know more about that paragraph than the judge who wrote it knows about it. So, here are some questions to ask yourself as you contend with that paragraph. Do I understand every word and every phrase in this paragraph? If the answer is yes, okay, you can check that off. If the answer is no, obviously you're going to go back and wrestle with it some more. Do I understand the facts contained in the paragraph? And this would obviously, typically there's a section in most opinions that talk about the facts, but facts are also, those facts are used elsewhere in the opinion, and so you want to think about, number one, what the facts are, how one fact relates to another, and why is that fact included? Do I understand how these facts relate to facts covered in previous paragraphs? Why are they connected? How are they connected? Do I understand the legal analysis? How did he get or she get from point A to point Q? If I have wrestled with the material and cannot master it, what is my plan? Am I a member of a study group? Can I sit down with my colleagues and wrestle with it? Obviously going to see me would be a great choice as well. You may want to Google things. If you haven't gone to the law library, the Spring Creek Library, and actually looked at the head notes and the syllabus, that can be a great resource to help you understand it. Don't leave that paragraph, though, until you can answer yes to all of these questions. And if you can't answer yes, you have a plan. Not a plan that you're kind of sort of maybe going to do, but that you are committed to doing. And then you're ready for the next paragraph. You may want to, it's going to depend to some extent upon the complexity of the case and the length of the case, but you may want to go back and read that case one more time, because if you've really dived down deep into each paragraph, you're kind of in the weeds, so to speak. You may miss the trees because of all the forest, right? Or you may miss the forest, I guess, before all the trees is what I meant to say. Okay, so here's the next step. This is how I do it when I really have to understand a case. This is my approach. I get out my highlighters. I print up the case, and I will highlight, or actually, you can just also do this online by using the highlighting approach online, and it's probably actually better to do it online, is you'll highlight. The colors aren't important. You can use whatever color you want, but you pick one color for all the facts, one color for all the procedural history, etc., etc. You highlight, and you'll see at the end, almost every single solitary word in your opinion is going to be highlighted. I mean, there might be a few therefores and other transitional phrases that don't get highlighted, but you know what? This is the opinion, so pretty much everything ought to be highlighted. And then you're going to, well, okay, so that's it. And by the way, we'll be using highlighters a lot in this course. If we haven't already, be sure to bring your highlighter so that you'll be able to take advantage of these tools, because these can help greatly. Sometimes one of these items will fit into more than one category. For example, the judge might be talking about a fact as he analyzes that fact. And so you might need to actually have, some kind of color coding where you actually have two colors on a particular item. I should have reversed this. This should be, let me put this the categories above. That would make better sense now, wouldn't it, Gruber? Okay, there we go. Sorry about that. Okay, so now you're going to read the case again. This is your third or fourth go through, and you're going to highlight. And I say here half or more, but it'll probably be more like 75% of the opinion is going to be colored. If you find significant areas that you're not highlighting anything, challenge yourself. Go back and make sure you're not missing something, because it's pretty unusual for there to be kind of nothing in a particular section that isn't highlighted. Okay, so then what's the next thing you're going to do? Well, you're going to transfer this material to a separate page. And again, if you're doing this online, you're going to be cutting and pasting it. You're going to be looking for all of your yellow facts, and you're going to cut and paste it and plop it into a new document, and that'll be your fact page. And then you'll have a pink page and a blue page and an orange page and a green page. And again, if there's particular content that you decided was both you know, a fact and an analysis, then you're going to have that particular section on 2 different pages. And that's not an unusual thing to happen at all. And so you'll have probably something like 6 different categories. So 6 different pages. And some of your pages might actually end up being 2 pages. So you might have, you know, 2 pages of facts. So you may actually end up having more than 6 pages. You're not editing at this point. You're not cleaning it up. You're just cutting and pasting it. It's going to not make a lot of sense and not be an especially attractive or a well-written document. Once you get all of the data there, now you're going to start cleaning it up. Now you're going to change all that highlighted stuff into stuff you can actually use in your case brief. You'll want to rewrite almost everything in your own voice. Use your own voice. Your own words, in other words, is what I'm saying here. You want to avoid using direct quotes as much as possible. It's not that you can't ever use direct quotes, but if you have more than one in a case brief, I would challenge myself on that. I think 1 is probably okay, but more than that, you're probably doing too much. You're going to paraphrase. Now you say, well, why not just use a quote instead of paraphrasing it? Well, there's 2 reasons. The first reason that you want to paraphrase is that you want to have a document that is super easy for you to read and understand. If it's written in your own words, it's super easy for you to read and understand. And honestly, the words of the judge aren't going to be as easy to understand. They may be easy for him to understand or her to understand, but you aren't him and you aren't her. Plus, there's somewhat of a stilted, formal way that opinions are written that don't lend themselves to kind of very quick understanding of the material. And so putting it in your own words is going to make it that much more accessible. It's comparing Shakespeare with a murder mystery novel. Shakespeare's beautiful and awesome and tremendous, but you can't read Shakespeare as quickly as you can read, you know, a murder mystery novel that you pick up at the dime store. So that's one reason that you want to put it into your own voice. But probably the bigger reason is that you're trying to master this opinion. And, you know, taking somebody else's quotes doesn't show any level of mastery, doesn't get you to a point of mastery. But when you're faced with a quote, you're saying, well, what does this really mean? Well, let me try to say it in my own words. Well, no, I don't think I quite have the meaning there. Well, again, you're wrestling with it. The act of paraphrasing it is wrestling with it. It's forcing yourself to say, I can't lead this until I understand it. You know, putting quotes around it is a cop-out for the most part, because I'm saying I'm not going to make this my own. I'm going to just use somebody else's words. Of course, you have to be careful not to change the meaning. That's obviously not okay, not the point. So you constantly have to go back to the original material and say, does this mean the same thing as that? Okay, now you may be thinking, you started off by telling us this document is supposed to be brief. It's supposed to summarize. But if you're at this point, you might well find that your quote-unquote brief is longer than the original case was. That's okay. At this point, we are not cutting out content. We're just translating the content into the writer, your way of looking at the world. You're taking the lens of the judge and replacing your lens. And so this is what I call a mental dump. You're not editing. I mean, you're editing in the sense of paraphrasing it, but you're not moving stuff around. You're not reorganizing it. You're not making editorial decisions other than the translation. But you're just trying to get everything on paper. Some people call this kind of the madman stage of legal writing. It's a tremendously useful tool for many of us to use, and I encourage you to think about it, and we'll be covering that in other discussions. But it's okay. The writing process should be messy. The first 3 or 4, certainly the first 2, and probably say 2 to 4 drafts of your documents are going to be awful. They're by definition awful. Nobody's second draft is worth anything. Shakespeare's second draft wouldn't be worth anything. Hemingway's second draft wouldn't be worth anything. probably, my second draft won't be worth anything. Probably your second draft isn't worth anything in and of itself, but you know what? It's a necessary step to that amazing, awesome 8th draft. And so it's part of that process that you go to. It's a little bit like baking a cake. Well, actually cake batter tastes pretty good, so maybe it's not a good example. But let's face it, when you're baking the cake and you're sifting the flour and you're breaking the eggs, that doesn't look much like a cake, but guess what? You can't make a cake without breaking a few eggs, as they say. And similarly, the first and second drafts don't look anything like your final brief, but you sure need to have those to get to that final destination. Okay, so we have our 6 pages, and you're going to organize them into a Word document. And again, as I say, you can do this manually, or you can just cut and paste and transfer it. And then you're going to organize it within our paradigm, because remember we have that IRAC setting. So you're going to have all of your, let's see, and you probably no longer have it color-coded, but all the facts that were originally yellow are all going to go together. There's just one place for your facts. And then all of your procedural history information is going to go together. And now you're going to sort. Let me go back here. Remember we had all of our issues? Well, you may find that there were 4 issues. And so now you're going to start, because you had all of your issues on one page and you had all of your rules of law on another page, you had all of your analysis on another page. Now we're going to sort within those pages. And so you're going to take one issue off of your issues page and then find all of the rules of law that relate to that one issue. And then you're going to find all of the analysis that relates to that one issue. And then you're going to probably look for well, eventually look for your facts. We won't do that quite yet. So you have your issue 1, IRAC analysis, your issue 2, IRAC analysis, your issue 3, IRAC analysis. And then you're going to have your overall conclusion and what is the disposition of the case. So you have a conclusion for each one of your issues, and then you have your overall conclusion. This is the structure of your case brief. Now you still don't have, well, you probably have complete sentences, but you still don't have it organized in any sensible way. It's still a train wreck. But at least now we have the bones of it. You can imagine a skeleton. You have the leg bones connected to the thigh bone. There's just no meat on it yet. Or there's no muscle, or there's no sinews on it. You still have a lot of work to do, but you can at least kind of sort of see the structure. Okay, so we're ready kind of to do more of the cleaning up. We're really kind of getting more towards, we're still not at the polishing stage, but we're to the point that we can see we're adding the flesh, we're adding the muscle, we're adding the sinews. Move things around so the connections are clear. You may find that, going back to our rules of law, or actually let's say our analysis page, you might have on a page one item up here and then another item down here, and you really need to move those 2 closer together so they make sense. And you may need to add connector words so that they make sense. So be prepared to move things around. The judge may not have organized the material in the way that makes most sense to you. It is absolutely fine. It is a good thing for you to move things around when it adds and helps your comprehension. Keep in mind that some rules, some analysis, and some conclusions will appear multiple times. Many times in these cases, the issues are pretty close to one another. They can be completely disparate, but oftentimes they're pretty close to one another. So if you have 2 issues that are really close, you may well find that the issue will share rules of law. So there will be times where your R section might be identical between your issue 1 and your issue 2 section. And there may even be a little bit of overlap, but even in the analysis or the conclusion section. When you're talking about the facts and the procedural history, you're going to do those chronologically. So you literally can establish a timeline. In fact, I like to do a timeline. That's my preference, especially if the facts are pretty numerous and confusing, where what's the first thing that happened? What's the second thing? What's the third thing? What's the fourth thing? And typically, I'd say probably 95% of the time, the facts will come before the procedural history even starts, because procedural history is the history of the lawsuit. The facts are what happened, what motivated somebody to file a lawsuit to begin with. But the procedural history doesn't start until that complaint or that petition is filed in court. And then at that point, the procedural history is the story of the lawsuit. You can read a procedural history of a case and have no idea who's or why the lawsuit has happened. You don't know necessarily whether it's a contract dispute or a car accident or some other matter, because you're just hearing about, well, this motion was filed and the judge ruled this way and this evidence was entered and those things. So it's really the story, the facts of the lawsuit, not the facts of the case. So that's why the facts comes first, and then you have the procedural history. In some smaller, shorter cases, you might even have these two sections combined. For clarity, again, so that you can very quickly find that content, you're likely to separate those in a case brief because, again, maybe the professor calls on you and says, tell me about the procedural history of the case. You want to be able to immediately find that section of your case brief. If it's buried in your facts, and you're nervous, it can add those few extra seconds, and it can be not as a pleasant an experience for you. Sometimes people are tempted to change chronological order. Maybe there's, in your timeline you have 7 facts, and fact 4 is really the fact that's most interesting, most surprising, most important. And so you might think, well, let me start with that one. Don't do it. Almost never will that work. Even if fact 1 is boring and mundane, if you need it, and again, you're really restricting yourself to just the facts you need, you start with 1, you go to 2, you go to 3, you go to 4. Now, you might spend more time with 4 than you do the other facts. You might start a new paragraph with 4. There can be lots of things that you do to draw attention to 4, but putting it out of order is not the way to do it. One thing that you'll want to do is mark dicta. Dicta are aspects of the judicial opinion that are not necessary for the holding. This is also called obiter dicta. And dicta is the plural form of it. You can also have dictum. But in everyday conversation, people call it dicta, which just means something that is said. It's Latin for that. So it's not really that a clear term. But what does it mean? It means it's stuff that the judge didn't technically have to consider or discuss, but chose to discuss. Let me give you an example. Let's say that I punch Bob in the nose and Bob sues me. The reason I punched him in the nose is that he said that my mother wears army boots. And I was offended by that, so I punched him in the nose. I claim that I had justification because he insulted my mother. The judge rules against me, unfortunately, and he says that no, Groover, you can't go around punching Bob in the nose, even if he says your mother wears army boots. But the judge wants to clarify exactly how broad this whole issue of insults works. So they might say, let's just imagine instead of saying, Groover, your mom wears army boots, Bob is still said, Groover, your mom is a mass murderer. Well, certainly that's a meaner thing to say about one's mother. But probably the judge would still say, you know what, even that wouldn't excuse punching Bob in the nose. But let's say that Bob said, I'm going to punch your mom in the nose, and my mom is right there, and Bob makes a fist with his hand and brings back his fist, and he looks poised to punch my mom in the nose. That's possibly when I am entitled to self-defense. So you can see the judge presented 3 stories. One is what really happened. Bob called my mother, said my mother wears army boots. The second, he says, Groover, your mom is a mass murderer. The third is, I'm about to punch your mom. Only the first one of those happened. The second 2 are dicta, because honestly, neither Bob nor I care about the second 2 scenario because that's not what happened, and so they are not directly relevant to my holding. But they can be useful to the case reader because the case reader's client probably didn't say your mother wears army boots. Maybe it's something kind of sort of similar to it. Maybe it's pretty different. And so by having a greater understanding as to the scope of this ruling, the case reader can have a better sense as to whether his or her case fits within the umbrella of this holding or not. Dicta is not as important, though, as the actual holding of the case. In fact, dicta is kind of like a little freebie, a little free advice. It is not a precedent that future courts have to follow, although courts oftentimes will follow dicta. So it's kind of like an advisory opinion, but it is not a mandatory precedent at all. For this reason, you want to mark dicta. You might use italics. You might just say, this is dicta, to show that it doesn't have as much weight or significance as the actual holding in the case. Obviously, you want to make sure that you're talking about the statutes or regulations in the cases. You're going to want to name them, and you're going to want to describe them. And now you don't have to independently go to other resources. So let's say in the case they mention Juarez versus Green. But you know what? They only shared 2 sentences about that case. And so you really don't know who Mr. Juarez is or who Miss Green is. You might be tempted to go and find that case and read it. Well, certainly that could be a good thing, but you're not required to do that for a case brief. Now, let's say that in the judicial summary about the Juarez versus Green case, they say that it talks about the doctrine of res judicata. Well, you will have to find out what res judicata means. You could, I guess, go to the case and find out directly from the case, but you could also Google it and find out from that perspective. So you don't actually have to do independent research other than get to the point that you have the information that the judge is assuming that legal professional would already have. So be sure to talk about all of the things that are in your rules of law. If the judge put it in there as a rule of law, almost certainly he's going to use it in some sense. He or she may well put in some facts that he doesn't use or she doesn't use, but the rules of law he or she's going to use. And so if you find that you aren't including them in there, that probably means that you're missing something. Your case brief should contain the definitions of tricky terms that you found in the opinion. This you may have to find on your own. If the judge used the term res judicata, he may well not define it because it's a term that most legal professionals are going to be familiar with, and if they need a little brush up, they're going to go to a legal dictionary. Well, if you're in the middle of you're a law student and the professors ask you a question, you don't want to go to your legal dictionary. You want to have the definition right there. So when he says, what's res judicata? You can say, why? Here is the answer. And you can read out the definition from the textbook or from the dictionary. Okay, now you're going to want to edit your content until all of your items are in complete sentences. Now I will be honest with you. When I would case brief in law school, I did not write things out in complete sentences. For one thing, I was taking 5 courses, and I was having 5 cases to read a night. So I was reading 25 cases, and there's just a lot to write in complete sentences. Plus, bullets were actually kind of more practical because you could see where one item ended, and it was more designed to kind of jog your memory, because after all, I just read the case the night before, so I still remembered it. But for the purposes of this class, we're going to be writing exclusively in complete sentences. So it's a little bit of a difference. You might think about this as being a kind of a enduring case brief, a case brief that you might refer to in the future when that case isn't quite so fresh in your recollection. You want to make sure there are no gaps or leaps in the case logic. You might even want to read it to somebody who isn't studying the law, somebody, say, who's, I would say at least 15 maybe, and have them read it and ask them, do you understand it? Do you have any questions? Were there any steps that didn't make sense to you? If they don't get it, you're not done, because a case brief should really, I don't hate to use this term, but it really should dumb it down. It should be so that, a bright, intelligent high schooler who has no legal background can read that opinion and get what happened. And so if your practice reader says, I don't see why that happened, or I don't see why you say this here, go back and add what you need to so it makes sense. So at this point now, who knows how many additions or revisions we've gotten to. We are now ready to edit for style, for flow, for style, for grammar, for punctuation. Up until this point, don't worry about grammar. Don't worry about punctuation. Don't worry about passive voice or transitional phrasing or things like that. All that stuff is important, but it's the icing on the cake. You need to have the substance there. You need to have the ideas there, and now you're ready to dress them up. They need clothes. Boy, do they need clothes. If you don't put clothes on them, you can't take them anywhere. And so it's essential that you have closed the grammar, the punctuation on it. But you want to save this to the end. If you start working on these things too early, what you're going to discover is you waste a lot of time, because you're going to move things around and you're going to slice and dice sentences. And so if you've made a beautiful sentence and now 2 revisions later, you've decided, well, that sentence isn't going to work there. I'm going to have to break it up into 2 different segments. Well, all the effort you did making that brilliant, beautiful, perfect sentence was wasted. So save this type of editing until you're really at the end. Case briefs can be longer than the original opinion. That is common, especially when you first started, because you're really trying to take really sophisticated ideas and get it to a level that you can understand. The judge is assuming a pretty sophisticated audience. He's not writing it to that intelligent high school level. So that's not a bad thing if your case brief is longer. In fact, it is rare that I've gotten a long case brief that wasn't better than a short case brief. I don't grade based upon length, but almost always when I get my stack of case briefs, I will look and I will see I'll put the longer ones on the bottom and the shorter ones on top, and I will grade them. And invariably, you can just see the progression of grades from lower to higher. So and that's true for virtually everything we do in this class. The longer your project is, it's likely your grade is going to be better. And you will find over time that your briefs do get shorter, so that's okay over time. Another thing to keep in mind is that a case brief is more about the process than the final result. It is the process of discovering what the judge was getting at. If you at the end really, really understand the case, you should be able to communicate it. If you don't really, really understand the case, your case brief can't be good. So it's really about that discovery, about that thought process, about analysis. So you really want to understand the logic of the court's position. This does not mean that you have to agree with it. I mean, you could brief an opinion that you absolutely, positively can't stand, completely disagree. You think the judge is the biggest jerk in the world, he's an idiot, he's a racist, he's a sexist, he's a whateverist. But that shouldn't show in your case brief. You are just summarizing it. Your opinion is irrelevant to the case brief. And in fact, when I was in law school, the professor never asked our opinion, what do you think the law should be? But it was, what do you think the judge would do if we changed the facts around? Your opinion isn't part of it. Obviously, you're entitled to your opinion. Share it with your family and friends, but it doesn't go in the brief. When you are done, you ought to be able to predict how the judge would rule in similar cases. If you can't, and you may want to play around and say, well, what would the judge do if the facts were a little bit different? And be able to say why, then you need to spend more time with the case. Come see me if you need some more support. Okay, so we're going to talk a little bit about a particular judicial opinion. This is one that we cover in the intro course, so you should be familiar with it. You'll probably remember a little bit about it. This case, by the way, is available on, I guess I should change this to Canvas. So you can read the whole case. You can also find it on Google Scholar. So here we have the case. Let me make it a little bit easier to see. And let's talk a little bit about the structure of the case. Okay, we start off here with the parties. We have the Boston Housing Authority versus Emmett Bridgewaters. Then we have the court that's deciding this case. This is the Supreme Judicial Court of Massachusetts, and we have the year that it was decided. Then we have the citation. These are called parallel citations. The state of Massachusetts still has its own reporter system. Texas hasn't had one since the 1960s. And so we would not have in Texas a similar site to this, but this is the state reporter system for Massachusetts. But of course, everyone really uses the West Reporter Series, and the Reporter Series that covers the state of Massachusetts is the Northeastern Reporter. Just like we have the Southwestern Reporter, they have the Northeastern Reporter. These are the same document. These are just different places of finding it. So again, this is the 452nd volume of the Massachusetts Reporter, starting on page 832. The same case appears in the Northeastern Second Edition Reporter in volume 898, starting on page 848. and this is the docket number. Honestly, you don't need the docket number. It's very rare that you would actually need that. Then this is that syllabus that we talked about. In this particular case, this is not the syllabus that West produces. This is the syllabus prepared by the state. And so this gives you an example, but the syllabus that we would have in the Southwestern Report would be very similar to that. So this is the background. Again, this is going to be the facts, and the procedural history is going to be here. Background. The Boston Housing Authority brought summary process action against tenant in public housing complex seeking eviction of tenant. You may notice that this is written almost in broken English. Obviously, you won't want to mirror this language. You'll want to write them in complete sentences. Obviously, you'd say seeking the eviction of the tenant. The Housing Court Department, Suffolk County, Boston Division, Stephen D. Pierce, then you have comma, J, period, comma. That means he's the judge. He is the judge who handled this case at the Housing Court in Suffolk County. And then we have a citation. It appears in Westlaw. Evicted tenant and tenant appealed. The appeals court, and again we have a citation where to find that opinion, affirmed. This gives us the background. So you can see now we're in the Supreme Court of Massachusetts. We started out in a trial court, which is this housing court department, and then we had an appellate court level, and now we are at the highest court in the state of Massachusetts. So in this brief summary, we have both the facts and a very brief introduction to the procedural history. Now we have the holdings, and we can see 1, 2, 3. On application for further review, the Supreme Judicial Court, and then we have CJ here, that means Chief Justice. So Chief Justice Marshall wrote the opinion, held that. So now we have the holding. So when you see the word held that, this tells you what the holding is. So you can see 1, 2, 3. There are 3 holdings in the case. So right here, we could take this, make them into complete sentences, and we have the holdings of the case. So the first holding would be, the housing authority had noticed that the tenant had a mental disability, period. That's holding 1. Holding 2 is the tenant made a reasonable accommodation request, period. And we have a third holding, that the housing authority was required to consider whether a causal link existed between tenant's disability and assault, period. Now, I'll be honest with you, the third one is really the holding, and these are the baby steps that get you to the big step. So I think this is written in a little bit maybe not the absolute best way. So you just as I said before, the syllabus is not written by the judge, so you have to use some critical skills as you read it. Then we find out how the case got here. Or actually, this is the disposition of the case. This is what's happening. So the judgment of the appeals court is vacated. A vacation means basically, doesn't mean a trip to Maui, although that'd be nice, wouldn't it? A vacation is the erasure of that decision. It's no longer good law. Let me pause here and talk about this. When this opinion was vacated by the Supreme Judicial Court of Massachusetts, did West go back and find this volume, call everybody up who they had issued this volume to, and said, okay, everybody, you're going to have to tear out these pages? Is that what they did? No. If you go, we don't happen to have this in our library, but if you went to the 871st volume of the Northeastern Second Reporter and turned to page 1107, there would be no indications that this isn't a good opinion, that this isn't completely the law in the state of Massachusetts. There are no signs, because this volume was published. You can see that the case that overturned this volume was actually over 20 volumes later. It's 27 volumes later. So this has been sitting in people's libraries for years, and nobody is going to send them. No one's going to send the people a note and say, "Hey, take those pages out." So that's one of the reasons we'll talk about later. But how you always have to shepherdize cases. This opinion is no longer good. The Supreme Court is saying, "Boy, those idiots on the appellate court really messed up big time." Then they remanded the case to the housing court. Well, you may be saying, why did they remand it? What does remand mean? And again, you'd be going, if you're reading this case, you'd be going to your legal dictionary to find the meaning. What remand means is send it back. to that court for further proceedings. Now you can see that in this case, the housing authority evicted, the appellate court affirmed, in other words, they agreed with the housing court. Obviously, the Supreme Judicial Court of Massachusetts disagreed with the appeals court, which means they also disagreed with the housing court. So by remanding it to the housing court, they're not saying, housing court, you did a great job, we want you to spend more time on this. No, they're saying you screwed up big time, you got to fix it. And that's what's going to happen, because what's going to happen is something about, we don't know yet because we haven't read the opinion, but something about this ruling is incomplete. There are steps that still have to be done, and those steps are going to be done by the housing court. Cases are remanded back to the trial court. They're not remanded back to the appellate court because trial courts have certain functions. They are the people who make findings of fact. They are the people who can accept evidence. Appellate courts don't do that kind of stuff. So it will always go back to, if there is a remand, it's going to go back to the housing court. Not every case is remanded. Most of the time, if you have a complete affirmation, I guess, of what happened in the lower court, there's no need to remand. But even in cases of reversal or vacation, there is not always a need to remand. It's not an automatic part of the procedures. But this case will go back to Judge Pierce's court if he's still sitting as a judge in that court, and he will be required to follow the instructions and take the steps that are necessary. Next, we're going to see the names of the counsel, the names of the attorneys who represent the party. So we see the representative of the defendant. In this case, we know the defendant is Mr. Bridgewater. So let's go back here, because this lawsuit was initially filed by the Boston Housing Authority. It brought summary process, which means they sued the tenant, Mr. Bridgewater's, seeking eviction of tenant. So who is the plaintiff in this case? Well, the plaintiff is going to be the Boston Housing Authority. Who is the defendant in this case? Mr. Bridgewater's. So Ann Jochnick, Richard Bauer, and James McCrate are representing Mr. Bridgewater's, and Jay Koplov is representing the plaintiff. Let's go to the next page. Here we're getting it. You'll notice that in this particular volume, by the way, there are no head notes because that is a proprietary tool of West. So we don't see those. But ordinarily, we would see, actually, we would see them. Trying to remember the order. Can't remember if it goes right here. I think it does. I think it goes right underneath the syllabus. But either it goes before the opinion starts. You'll see all the head notes. And again, the head notes are going to be significantly longer than any of this content, but shorter than the opinion. Okay, so you know you're getting ready for the opinion when you see someone's name, comma, and either the word justice or chief justice. That tells you everything after that is written by the judge. There are no editorial comments at this point. Every single opinion, whether it's the official opinion or the unofficial opinion, the West law or West opinion, are going to be word for word the same. That's the reason why we don't really care in the law whether you use the official opinion or the unofficial opinion. They have equal weight. And in fact, actually, the unofficial opinion is oftentimes preferred because more people have access to the West publications than they would, say, to the official publisher. So don't get bent out of shape if somebody says, well, you're using the unofficial reporter. Nothing in the world wrong with that. So let's look at what Chief Justice Marshall has written. He has his first section, which is the procedural background. And then he goes into the factual background. Let's pause so you can see his organizational system. He has procedural background, factual background. By the way, these little asterisks here, that's standing for material that has been deleted, that the textbook author has decided isn't worth spending space on. In the actual opinion, we'd have content here. So this justice chose to begin with a procedural background. It's probably more common for opinion writers to start with a factual background because, of course, the facts happen first. In this case, we'll learn, here we go, the facts that are important are going to be, well, what did Mr. Bridgewater's do that made the housing authority want to evict him? That's probably what the facts are about, right? And then The procedural history is going to be, well, what happened once the Boston Housing Authority decided that they wanted to evict him? What did Mr. Bridgewater's do? What did the Housing Authority do? All those events. So obviously if Mr. Bridgewater's hadn't done something to start the process, act up or whatever it was, we wouldn't even be here today. And so this order is a little bit counterintuitive, but sometimes judges do use it. So just be aware that the procedural background can come first or the factual background can come first. We're not going to spend time reading the procedural history, but let's read a little bit about the factual background. We summarize. Let's pause here and say, we? Why are we saying we? This is written by one guy, Mr. Marshall here. So why is he saying we? Well, very likely, we don't see this yet, but very likely he is writing the opinion of the court. And I'm guessing in Massachusetts, there are probably 9 justices on the court. And so probably at least 5 of the justices have agreed with his opinion, have signed off on his opinion. So even though he's the author of it, he has other people saying, yep, that sounds good. Yep, I'll sign my name to that. And literally they do sign their name to the opinion. So when he says we, he means all the other judges who agree with him that are on the Massachusetts Supreme Court. So we summarize the facts found by the judge. Who's this judge? Let's go back here. That's Stephen D. Pierce, the judge in that trial court. So we summarize the facts found by the judge, supplemented by undisputed facts of record and uncontested affidavits and exhibits considered by the judge in Bridgewater's post-trial motions. So you may be wondering, what are facts of record? Might want to Google that, look that up in your book. What are affidavits? Not quite sure about that either. Again, it makes sense to look up these terms if you aren't rock solid that you know what they are. Okay, let's keep on going. The BHA, and again, we would have seen earlier what BHA stands for. We can see it here. They put it in parentheses. Boston Housing Authority, the BHA, owns and operates Holgate Apartments, a federally assisted residential complex for the elderly and the disabled, where Bridgewater's lives. His twin brother Eric also resided at Holgate in a different apartment. In the late evening of January 9 or the early morning of January 10, 2004, Bridgewater's assaulted Eric inside Eric's apartment. Okay? As a result, let's pause here and say, now, it could well be that Eric, especially since he's his twin brother, probably has the same last name as Emmett, right? Emmett Bridgewater's, probably his twin brother is Eric Bridgewater's. But you notice that they use Bridgewater's to refer to Emmett, and they use Eric to refer to Eric Bridgewater's. They want to have the terms clear. If they referred to them both as Bridgewater's, it would get confusing, right? Because they're both Bridgewater, so you wouldn't be sure who's doing what. Now, they could have referred to them both as Emmett and Eric, but that's a little bit informal for legal writing. Typically, people are going to use surnames. But they have this extra wrinkle. Well, again, we can't say Bridgewater's both. So they could have said Emmett Bridgewater's each time and Eric Bridgewater's each time, but that gets to be a little clunky. So they made an editorial decision to say Bridgewater's for Mr. Emmett Bridgewater's and to refer to Mr. Eric Bridgewater's as Eric. Okay? In the late evening, Bridgewater's assaulted Eric inside Eric's apartment. As a result of the altercation, Eric, who was paralyzed on the left side of his body due to a stroke he suffered as a child, sustained severe injuries and temporary paralysis in his right leg. After the assault, the BHA brought this action, meaning this particular lawsuit. In this context, action means lawsuit. The BHA had not previously attempted to terminate Bridgewater's tenancy. And of course, we're talking about Emmett Bridgewater, not Eric Bridgewater. So here are the facts. During the trial, Bridgewater's, who was not represented by counsel, testified that he had not initiated the assault, that he had punched his brother once, and that he had thrown water at him. Bridgewater's also testified that he suffers from a mental disability, which he termed manic depression or bipolar disorder. He stated that he had been prescribed medication, but that he was unmedicated at the time of the assault on the advice of his physician. In support of his, and again, this is showing some materials left out. We don't know what that is, but for our purpose. In support of his post-trial motion, Bridgewater submitted affidavits and exhibits that elaborated on his trial testimony. These materials indicate that Bridgewater's had been determined to be disabled by the Social Security Administration and unable to support himself, and that he was diagnosed with bipolar disorder and borderline personality disorder. You might want to look up to see what the term disabled means in this context. See what that statement means. It's a pretty high threshold to be declared disabled by the Social Security Administration. So we know that from the Bones perspective, we have the procedural history, which is the story of the lawsuit. We have the factual background, which is the story of the events leading up to the lawsuit. And now we have our discussion section. And you can see there will be subheadings under discussion. This is where we're getting to the analysis section of the case. Because the issue whether Bridgewater's had a reasonable accommodation request, and again, you'll want to look at what does reasonable accommodation request mean. We got some hints here. We didn't spend time on it, but there's a note here on this slide that gives a little bit of information about that. Because the issue whether Bridgewater's made a reasonable accommodation request rises meaningfully only if the BHA is obligated to entertain his request, we must first address whether Bridgewater's misconduct foreclosed consideration of any reasonable accommodation request. When you see words like we must first address or we first address, that is an indication that we have, I'm not going to let me highlight this, but this is an indication of an issue. So the issue, when you see the word whether, when you see address, or you see the word issue. So we could say, did Bridgewater's misconduct foreclose consideration of any reasonable accommodation request? That might be our first issue. Okay, then we have our next point, A, the direct threat exception. Much of this case turns on what is known as the direct threat exception to a public housing authority's ordinary obligation to accommodate tenants with disabilities. So you'd want to find out about what is that. Probably you're going to be citing the law, the statute, and figuring out what those terms mean. What does direct threat mean? For example, is it a threat to yourself? Is it a threat to somebody else? Is it a spoken word? Is it a physical action? All of those things. Does it have to have some physical implications, or would a direct threat be, I'm not going to date you anymore, or something like that? Okay, now we have B. So we had A, now we're up to B. Reasonable accommodation request. Because the BHA's obligation to assess individually whether Bridgewater's posed a threat to the health or safety of individuals turned on whether Bridgewater's requested reasonable accommodation, we now address whether the BHA knew that Bridgewater's was disabled and whether he made a request for reasonable accommodation, leaving for later discussion the BHA's claim that no causal link existed between Bridgewater's disability and the assault on his brother. Wow. That is one ugly sentence. It is a full sentence. All of this in paragraph B is one sentence. Ladies and gentlemen, that is poor writing. Good rule of thumb is you want to restrict your sentences to under 20 words. There's probably at least two, I'd say probably at least three sentences lurking in here that we ought to break up. Don't fall into the trap that this judge wrote. He did not write an effective sentence at all. But this is our second issue, isn't it? We now address whether. The word whether is a good clue. And again, you can word search for this stuff if you have the document downloaded. Whether, okay. So the issue might be, did Bridgewater's know that, excuse me, not Bridgewater's, did BHA know that Bridgewater's was disabled? That might be another issue. Now that's more of a fact issue than a legal issue. I mean, you can look at the transcripts and figure out no, I mean, obviously this was a residential facility for the elderly and the disabled. Maybe Mr. Bridgewater's was elderly. We don't know that for sure, but it seems kind of likely that BHA knew he was disabled. Let's look at the next one. We have another whether, which shows us another issue. Whether he, meaning Bridgewater's, made a request for accommodation. So our third issue might be, did Bridgewater's make a request for a reasonable accommodation? Well, we actually know the answer to that question. We can go back here and look. Let's see, I know we saw it somewhere. Thought we did. Anyway, somewhere in here I think is a request for accommodation. Okay, but obviously you'd go back to record. So again, this is more of a factual inquiry than a legal issue. So we've covered the first whether, we've covered the second whether, and now we are here for this part that says leaving. Leaving for further discussion, BHA's claim that no causal link existed between Bridgewater's disability and the assault on his brother. So now we have a fourth issue. Was there a causal link between Bridgewater's disability and the assault on his brother? And now we have the fourth section. This is a conclusion. It's pretty common that you're going to have this label. It makes a nice roadmap. This is going to be that final paragraph. Bridgewater's twin brother has the right to be safe and secure in his home, as do all tenants of public housing, and hopefully all tenants everywhere, right? We do not minimize the severity of the attack on him. However, the law mandates that before a public housing authority may terminate the lease of a disabled tenant such as Bridgewater's because he poses a significant risk to the health or safety of others that cannot be eliminated by reasonable accommodation, the housing authority must make an individualized assessment based upon reasonable judgment that relies on current medical knowledge on the best available objective evidence to ascertain the nature, duration, and severity of the risk, the probability that the potential injury will actually occur, and whether reasonable accommodations of policies, practices, or procedures will mitigate the risk. No such assessment has taken place in this case as it must. So here is where we get the holding of the case. They actually didn't label it as holding, but that's what it is. This list of stuff. The housing authority must make, and this actually, since in quotes, is probably from a statute or regulation. This is the type of analysis that they have to make. And then the court found there was no such individualized analysis in this case, and it has to happen. And then we have the court order, which is another term for the disposition of the case, and this is typically going to be the very last sentence of the document. It's kind of a bit anticlimactic for you and me because we don't really care, and it's usually written almost in code language. We vacate the judgment and remand the case to the housing authority for further proceedings consistent to this opinion. Well, what is that further proceedings going to be about? Well, you won't find in this last sentence. The Judge Pierce, is going to have to read this whole opinion to get it, but what we can see here is the sentence right above. No such individualized assessment has taken place in this case as it must. So what the judge is going to have to do is make this individualized assessment. So he's going to have to make an individualized assessment based upon a reasonable judgment. He's going to have to rely upon current medical knowledge or on the best available objective evidence, and he's going to have to ascertain the nature, duration, and severity of the risk. He's also going to have to ascertain the probability that the potential injury will actually occur. In this case, it actually has occurred, but maybe whether it'll occur in the future. And the judge is also going to have to determine whether reasonable modifications of policies, practices, or procedures will mitigate the risk. And of course, you're going to want to look up the word mitigate to make sure you understand what that means in this context. That's what I've been trying to do, is model for you some of the steps that you would go through as you're reading the opinion. Okay, so let's look at some things about, or some structural things about doing this. We've read the opinion now we're going to try to make sense of it. And again, here are some tools that you'd want to do. You're going to want to look at the overall structure of the opinion. I tried to do that by pointing out the headings and the order of the material. You're going to want to find the dicta. Now, we didn't really see dicta in this because, again, it was kind of a Cliff Notes version. They had edited the stuff that might have been dicta. Here's an example of a little bit more clarity about the definition for holding and the obiter dicta here. And then here are some things that you're going to want to look at in your case brief. Now, we've already talked about FIRAC. This is a little bit different organization. The citation is just the names of the parties. In this case, Boston Housing Authority versus Bridgewater's, and probably the page that you would find it in the reporter. So I did not include that in my FIRAC analysis, but obviously you'll want to have that as the name of your document. Then we have facts. Now I said just facts here, but implicit in that is also procedural history. So when I say FIRAC, I don't mean leave out the procedural history. There might be times where you can get away with that, but there'll be other times where you want to include it. So uh, that would be correct. So we have issue, which attracts with my I here. And then we have these three items are really just a different way of packaging the RAC. They don't actually list the rule of law separately, but you could say that the analysis is the decision and the reasoning, and you could say the conclusion is the holding. So it's a little bit different way of organizing it. As I said before, IRAC is not the only way of doing this. It's just a really popular, a really clear way of doing it. And so for our course, we're going to do the FIRAC, but just be aware there are other ways of doing it out there. And this is how the textbook, our intro textbook, organized it. So this gives you some idea about how to approach it. I'm not going to go over this specifically, except to point out just a couple of things. First of all, you can see here that the writer of this textbook asks the questions together and gives the answers together. For our class, we're going to separate. We're going to have our issue one, we're going to have our answer one, we're going to have our analysis one. Then we'll go to issue two, answer two, analysis two. So we'll talk about that more structurally. And here is one way of looking at the Bridgewater's case using the IRAC method. So we have issue one. Did Bridgewater's conduct eliminate the requirement that the BHA consider his request for reasonable accommodation based upon his disability? And I've given one rule here. BHA is required to consider reasonable accommodation requests unless there is a direct threat. Obviously, you're going to need to expand upon that, talk about direct threat, but I only have a limited amount of space, so I kept it pretty brief. So we have our rule. Now we're going to do our analysis. BHA knew that Bridgewater was disabled but did not consider it. Again, we would expand upon this and talk about the whole direct threats thing in more detail. Then we have a conclusion. What's the answer? Well, BHA did not fulfill its obligation. So the answer here is going to be no, right? And then we have issue number two. Does BHA have a reasonable accommodation, Bridgewater's have a reasonable accommodation request that the BHA must consider? Now we're going to talk about what it means under these circumstances. The direct threat idea. The direct threat must be evaluated before reasonable accommodation can be ignored. And we have the analysis. BHA did not evaluate Bridgewater's conduct to see if it was a direct threat. And the conclusion is BHA cannot evict Bridgewater's at this time. So the answer to this one is yes. Now, again, this is just a very skeletal thing. I don't want you to think that this would be at all an acceptable case brief. I'm just trying to put a little bit of idea starters on your PowerPoint here. So if you have questions, please bring them to class. We want to talk through those ideas. Now I'm going to turn to some documents that you'll find in your folder for this module. So I'm going to switch from sharing this stuff to sharing some other stuff. So we're going, here's an example. This is from some material that LexisNexis produces. As you probably know, LexisNexis is a competitor to Westlaw. They have a similar product with online tools. And this gives an idea about how to case brief for law school. So this might be something that a future law student or a new law student might use to help him or her prepare for the case briefing. I'm providing this for you as a way of kind of a secondary tool to look at it, but just be sure that the terminology used here isn't exactly the IRAC method, and so you want to make sure that you're following the method that we've talked about in class. But this can be a good way, especially if you get stuck. What do I do next? I don't know what to do under these circumstances. You'll see many of the ideas that I talk about are in here, but there's going to be some other ideas as well. Okay, and now I'm going to go to another tool. Actually, let me save this one for a second. Pulled up the wrong one, I apologize. Here's another one kind of similar to the one that we just did from LexisNexis, and this gives you an example about the formatting. This is actually from a law school professor, and it gives an idea about how it ought to be formatted. And so this can help you figure out how to approach it. And again, this is actually a sample case brief for Roe v. Wade. Now, this particular instructor is very focused on keeping it brief. That is not what we're focused on. That adds just too much stress to this. It's hard to write briefly, a case brief. And so I don't want to add an extra level of stress to it. You are not limited in length, and as I said before, most likely the best grades in the class are going to be from those that are longer. Okay, so that's another tool you may want to look at, or you should look at as you prepare for your case brief and as you prepare for a test that we have in the course. Now I'm going to go now to the document that I accidentally went to before. This is the format. This is the nuts and bolts about how you ought to make your case brief look. Now I realize you've already completed one and I didn't tell you about this format because I didn't want you to worry about it. We were more interested in looking at your writing, the style, than about the nuts and bolts things. We can work the nuts and bolts out a lot easier than this. So now I'm going to tell you this is how it should look. Okay, you're going to start with the facts of the case. Obviously at the top you're going to have the name of the case and all that good stuff. I didn't put that here. So you're going to have the facts of the case and you're going to have them, and you're probably going to have a few paragraphs. But keep in mind, if you have a fact in this section, you need to use that fact somewhere. Now I will give you a little bit of leeway here. 80% of the facts you have here should be used somewhere else. If you decide, I encourage you to write your facts last, but if you decide to write your facts first, before you submit it, go through and highlight all the facts that you use elsewhere. And if you find that you have less than 80% of your facts highlighted, you need to cull some facts. The 20% of facts that you don't have highlighted that you can keep in are the transitional facts, because I mean, after all, you are trying to tell a story. And so sometimes you need to add a few facts to connect the facts that you're actually using. So it's reasonable to have up to 20% additional facts, but you really want to be very careful and cautious about how you use those 20%. The vast majority of facts you need to use elsewhere. Most of the time, it's not so much that the person who is doing the facts or writes the facts that they're adding too many facts. It's usually that they are underutilizing the facts in their analysis section. Then we're going to have the procedural history. You're going to use this in your case brief, but it is possible certain times that you may omit this. If the actual case doesn't talk about procedural issues, you don't necessarily have to include this in your case brief. Your procedural history section will probably be shorter, and you don't have to use the facts in your procedural history section somewhere in your document. That's not necessary. You may find that you do, and that's a good thing, but there's no need to be able to cite procedural history facts elsewhere. Then you're going to have your issue number 1. You want this to literally be a question with a question mark at the end. I mean, it reads like a question, and it ought to read as a question. When you hear it, you're like, I don't know the answer to that. It shouldn't read like an argumentative question like, is democracy a good thing? Well, we all agree democracy is a good thing. It ought to read like a question that you're not sure what the answer is. Issues are hard to write. The main reason that's hard to write is you have a lot of ideas to get into one sentence. The sentence has to be written as a question, and it has to be reasonably easy to read. The best issues are going to include some of the facts, but I don't want you to get so focused on writing the best issue ever that you don't write an effective issue. So for example, let's imagine a dog bite case. Let's say in this particular case, the plaintiff was bitten by the dog. He was a police officer responding to a police call. He entered the backyard, a dog bit him, and he sues the dog owner. You could say, as your issue, can plaintiff successfully sue the dog owner for his dog bite? That is the issue in the case, and it is written as a question. The problem with that issue is that it doesn't have, it's really a question that's only relevant to that plaintiff and that defendant. You know, if the plaintiff is Bob Smith and he's suing Mary Green, well, Bob Smith and Mary Green care a lot about that question. But unless you're representing Bob Smith, why do you care whether Bob Smith can sue Mary Green? So what you need to do is you need to make the facts more generic. So you might say, can a policeman who is responding to a police car and who enters the backyard of a house sue the owner of the house when the owner's dog bites him? You can see we have a lot of ideas going on, but that would be a reasonably effective way of approaching that issue. Your sentence is getting pretty long at this point, but you need to have enough caveats so that now when I read the question, I can decide, well, boy, the facts of my case aren't anything like that, or facts of my case are somewhat like that, and it's relevant to my case. There's unacceptable, where you don't have it in a question format and you haven't identified the correct issue. Acceptable, where you have identified the right issue, but you haven't made it generic enough or general enough. And then excellent, where you really have pulled the very few facts that are going to help crystallize the issue. And so there's kind of levels to writing the issue. So we've decided what our issue is, and now we're going to have our rules of law. Probably you're going to want to have a separate paragraph for each one of your rules. You're going to cite the rule. You can quote from the rule in this case. That's okay to quote from the rule, but you're probably also going to want to paraphrase the rule or point to the most important parts of the rule. If a particular case that you're citing or a particular statute has, say 3 things that have to be proven, those can be bulleted. In fact, it's pretty effective to bullet. You might actually bullet with a bullet, one of these little dots, or you might have, if they're put in a particular order, 1, 2, 3, 4, something along those lines. That can be an effective way of organizing. It still needs to be in complete sentences, but you can use bullets within those complete sentences. So we have our I for IRAC, we have our R for rule of law, and now we have our analysis. I'm calling it analysis here, but it can also be the application of the rule of law to the facts. This is the purpose of your document. This is it. This is the payoff. Everything up to this point is just to get you ready for this. It's a little bit like, let's say you were about to perform in Carnegie Hall. You practiced, you bought, a tuxedo or a fancy evening dress, you got your hair done, you put on your best shoes, you did all of the things getting ready. But if you never go on stage, let's say, you break your leg as you're about to go up the stairs, all of that's wasted, because it's all about your fingers on the keys in Carnegie Hall. And everything else was just to get you here. So reciting the facts is lovely, but it's only lovely if it helps you with the analysis section. So keep in mind, this is the main event. This is the only event, really. Everything else is just letting the reader has to know all this stuff before the analysis section makes sense. But the stuff before doesn't really have any importance unless you nail the analysis section. So you're going to want to reuse those facts and reuse those laws that you cited above and put them together. Then you're going to want to summarize about it. This can be very short. It doesn't have to be a lengthy section. It will basically be summarizing the analysis. When you're doing the analysis, by the way, you're going to want to use things like topic sentences. You're going to want to have support for each one of your topic sentences. Those topic sentences can give you some clues as to what you want to do with your conclusion. Then you're ready for issue 2. And it's the same pattern with issue 2. You're going to restate your issue 2. You're going to state all your rules of law with respect to issue 2. You're going to state your analysis for issue 2, then you're going to have your conclusion for issue 2, and then you'll go to issue 3 and issue 4 and issue 5 and you get the idea. Once you're done with your last issue, then you'll have your global conclusion. So we have our conclusion relating to our last issue, and then we have our global conclusion, which will remind the reader all of the lovely conditions that we've reached before. Okay? So I like to give you some previews of things that I have seen that students often do wrong, and I do this so that you don't have to make those mistakes. This is a cheat sheet, so when you are going through your case brief, and I recommend you read these before you start, but also before you submit it. Go through these and check off and say, yep, I did that, yep, I did that, oh, I need to make that change, okay? So first of all, double space your case brief. This is a silly way to lose points. Don't be that person. Double space it. We're going to double space it primarily because I need space to write comments, and so that really helps me give you more confidence. If you single space it, I can't give you many comments, and therefore it's not going to be as good of a learning experience for you, and it also is kind of annoying for me. It's hard for me to make comments under those circumstances. Okay, also remember we always use Times New Roman 12 point as your font. I would recommend that you just set it up as your font on your computer going forward, so it makes sense. Many times the fact sections are too long. Again, you don't want to use facts that you're not using elsewhere. We are going to have a procedural history section for this case, but you don't want to go overboard with it. You ought to include it, but we're mainly just doing it so we have the experience of writing it out. So it ought not be lengthy. This piece of advice I'm not going to bind us to because the procedural facts you're probably not going to be using for our case, so don't worry about bullet number 4. As we already talked about kind of the issues about, so we're now on bullet number 5. It needs to be a sentence ending with a question mark. It has to be written as a question. You're gonna need some time writing issues. The issue is probably the single hardest part to write. Again, you may want to have more issues. It's easier if you break down things into more issues than have just 1 or 2 big issues. You can have as many issues as you want. Sometimes it's helpful. It makes it easier to write the issues and do your analysis. Just organizationally, you don't want to put your issues together. So again, let me explain what I mean by this. I don't want to see issue 1, issue 2, issue 3, then rule of law for 1, rule of law for 2, rule of law for 3. Again, that's another way you'll lose points. No reason not to organize it the way that we have in this model. We already talked about bulleting. Everybody's analysis is always too short. A good rule of thumb is that your analysis section, if you add it all up, it should be longer than everything else. So if you have everything be a page, then your analysis section ought to be a page. So your document ought to be 2 pages. You need to have length here. This is why they've come. They didn't come to hear, you know, one line of the music. They want to hear the whole piece. Many times, I think the reason why the analysis is short is that the student skips over sections. You want to hold the hand of the reader and walk him through every single solitary step. Approach it as if this person is not the brightest person ever. And you're saying, well, we know this, so now we know this, so now we know this, so now we know this. Don't make jumps. It may be obvious to you how you got from A to Q because you're so smart, but keep in mind your reader may not be so smart, and so you want to connect the dots. Again, we need to have a conclusion. So you'll have, however many issues you have, you'll have that many conclusions plus 1 because you'll have that final conclusion. Disposition you'll want to include. It's not a tremendously important part, but it does belong in a case brief. And you can have your disposition. It belongs in your final conclusion, but if you want to break it up and have a little bit of your disposition in each section, you can have your disposition relating to each issue if you want. That's your judgment call about that. You can also put your disposition in your procedural history section if you would like. Keep your facts and your procedural history in the past tense. You can put the actual opinion of the court in present tense if you want. I don't recommend it though. We don't really cover a lot about tenses in this course. The subject of tenses in English is really, really subtle and really complex, and it's just beyond the scope of this course. The easy way of doing it is keep everything in the past tense. If you choose you have to keep the facts and procedural history past tense. If you want to have the analysis section in the present tense, you can do that, but you have to be consistent. You can't flip the analysis from past and present or whatever. Your facts are always going to be past tense, but your analysis can be present tense. But as I say, really, why look for opportunities to lose points? You're not going to lose points if you keep everything in the past tense. That's my advice. We haven't talked about, or we may not have talked about passive voice yet, but if that is something that you're familiar with, that we've covered, be on the lookout for it. I'm going to be on the lookout for it, letting you know what your grammar problems are. You will definitely want to look at it through the prism of grammar checks and passive voice checks before you submit it. The shorter your sentences are, the easier it is to avoid comma problems and other grammar problems. It doesn't really help you with passive voice, but the shorter your sentences are, the easier it's going to be to avoid some of the problems that the students oftentimes have. You don't want to get ridiculously short, so it reads like run, Jane, run, but rarely do I have students who write too short of sentences. Err on the side of shorter. Again, that 20-word limit is where you're going. So hopefully these hints are helpful for you. We've now concluded the material for the case brief, and class will work in more detail about case briefing, go through some additional examples. Please, please bring your questions so that we can field them. If you have the question, probably someone else in the room has it as well. Thanks for your attention. And I am going to end our presentation now.